Hi there, I'm Elizabeth Ritchie, here with my law partner, Neil Rambana. We're from Rambana & Ritchie, immigration attorneys in Tallahassee, Florida. We're here to tell you about the background of the President's executive order on immigration and the current status of that with the United States Supreme Court. In June 2012, President Obama issued an executive order that allowed undocumented immigrants who met certain criteria, like entering the U.S. before their 16th birthday, to apply for a work authorization and receive temporary relief from deportation. In November of 2014, the President issued another executive order which expanded deferred action for childhood arrivals and added an element for parents of children who are permanent residents or U.S. citizens.
In February 2015, Judge Andrew Hannon, who was appointed by President George H.W. Bush, issued an injunction basically stopping the 2014 executive order, in part on the basis that the order would cost the state of Texas millions of dollars due to the issuance of driver licenses to expanded DACA and DACA recipients. This is a false argument because the recipients would have had to pay for their licenses like any other applicant.
On January 19th of 2016, the Supreme Court decided to hear this case and take up Texas v. United States, in which Texas and 25 other states, including Florida, brought suit over the President's 2014 executive order expanding DACA and DAPA. The justices will likely hear oral arguments in April and make their decision in early summer.
Because every president since Eisenhower, including George H.W. Bush, has issued an executive order legalizing millions of immigrants no less than 36 times, and they've all been upheld as constitutional, including the President's 2012 executive order granting DACA for the first time, we're hopeful that the court will lift Hannon's injunction so that the President can take care to carry out his constitutional duties. If they do, about 5 million people who enter the U.S. as children and parents of U.S. citizens and permanent residents of any age could file for work authorizations and receive protection from deportation.
Doing so would also result in about $1 billion in increased revenue for the United States over the next decade. In Florida alone, there are about 250,000 eligible DACA and DAPA applicants. Their approval would result in about $102 million in increased tax revenue for the Sunshine State alone over the next 5 years. We are optimistic that the court will once and for all agree that the President has the inherent constitutional authority to issue immigration-related executive orders and that states don't have standing to bring cases like this. But in the meantime, undocumented immigrants who are in limbo should pursue other options than expanded DACA and DAPA.
Rambana & Ritchie will be filing our own amicus brief urging the court to uphold the lawfulness of the President's immigration executive order.
Stay tuned.